Thank you, Tracy, and good afternoon, everybody. And welcome to this webinar today, this Safe Food webinar, where we're looking at due diligence response and other legal aspects of catering for food allergens. So, as you know, the whole area of allergens and allergen warning has been in the media and in the press in recent times. There's a lot of focus on this whole issue from consumers, from caterers, and indeed from regulators. And this is all really down to the fact that the whole area of allergens and the injury and damage that can be caused to consumers where they inadvertently consume allergens can have very sad and tragic consequences. And I've just pulled out some headlines over the recent past relating to some incidents where consumers have in fact died from allergic reaction. You see there the BBC, where the pret-a-manger labelling was deemed to be inadequate after a 15-year-old died from allergic reaction to a sesame seed baguette. Also see there there was a second issue with pret-a-manger, and a second allergy death was named as a wonderful 42-year-old mother of 5. So another issue where a consumer passed away as a result of inadvertently consuming allergens. Of course, you also see from some of those headlines that the people responsible, the caterers and the people who were deemed to be responsible, in fact faced jail and were sent to jail as a result of the deaths that arose. So a restaurant owner who was jailed for 6 years over the death of a peanut allergy customer, and there in the sad case of Megan Lynch, a takeaway boss jailed over an allergy death. So this is a very serious issue, and it is very serious for obviously for those of us and those people who have serious food allergies, but also for the food business owner and caterer who is responsible for placing food on the market and for indeed offering food to consumers. So what I want to look at today in the course of this webinar really is the law as it relates to the area of allergens. What are the legal consequences? First of all, what are the legal obligations and what are the legal consequences? And how can caterers and restaurateurs and people providing food, how can they best protect themselves to ensure that they and you, those of you who are involved in the catering industry, how you do not find yourself falling foul of the law and indeed facing some rather horrendous consequences, not least the death of a consumer, which of course nobody wants, but also potentially legal consequences, which could ultimately result in jail. So that's what we're going to look at in the course of this webinar, and there will be an opportunity to answer questions, or to ask questions and answer questions at the end. But what I want to start out with is really, where does food law come from? And this is something that people often ask. They wonder, where does it come from? Where are these rules? Where do they originate? In principle, food law now, in the main, comes from the EU. It is generally harmonised across all EU member states, and it takes the form of either regulations, directives, or decisions. So the idea is that for the vast majority of food law in Europe, it is harmonised and is more or less the same across all member states. However, as many of you will know, that does not necessarily mean that the same rules apply in each country. So you will find there are national differences. And indeed, here in Ireland, we have some additional rules and additional requirements that are not necessarily the same as in other countries. So very often there are slight differences, but in principle, the law requires that there is a level playing field amongst European countries, which the idea of which is to give certainty to business, but also to give confidence to consumers. And most European food law these days originates from actions taken in the aftermath of BSE, which you will recall was a very large food safety issue in the mid-90s, mad cow disease, BSE, and as a result of that, a huge amount of new law was introduced, which really put consumers and food safety at the top of the agenda. And as we'll see here, food safety post-BSE really was top of the political and consumer agenda. And that remains the case today. And it is all about protecting consumers and protecting their health and informing them. And we will see that right through this webinar as we look at some of the specific provisions. But what I want to do is look here in an Irish context, and bear in mind when I talk in this webinar about the law, I am talking specifically about the law as it applies in Ireland. And whilst there will be obviously a resultant impact and a lot of the EU law is also included, we are really focusing here on Ireland. And in that context, it's interesting and I think useful to get an idea as to who is actually responsible for the enforcement of food law in Ireland. And you see from this slide that there are a number of different agencies. To the top, you see the government departments, which are specifically responsible for legislation and policy in the food area. So the Department of Agriculture and Food, the Department of Health and Children, the Department of Communications, Marine and Natural Resources. They are primarily the three departments that are most involved in the legislation and policy area for food. And then underneath that, you will see the Food Safety Authority. The Food Safety Authority was established in 1998, and the Food Safety Authority of Ireland is the authority with ultimate responsibility for the enforcement of food legislation on the island of Ireland, indeed certainly in the Republic of Ireland. And in fact, they work very closely with both Safe Food and with the Food Standards Agency, which is the competent authority in Northern Ireland. So the Food Safety Authority of Ireland is the central competent authority, and it is responsible for the enforcement of all food legislation. And the way that operates is that there are official agencies. So the Food Safety Authority has service contracts with official agencies, which include the Department of Agriculture, which include the HSE, and so the EHOs, and the EHOs who are responsible on the ground for the enforcement of food legislation on behalf of the FSAI. So these are the agencies that are involved, and that are the people who are responsible for the inspections and for sampling, and indeed for enforcement and taking action when there are issues. So it's important just to get an understanding as to the structure and how it works. As I said, food safety post-BSE and the mid-90s really became top of the political and consumer agenda, and it is the lens through which we must look at all food legislation. The object of it is primarily to protect consumers and to protect the health of consumers, and that is where the law as it relates to allergens is so important, and why it is such an issue and something that needs to be considered, because of course it is there, and the law, the rules around allergens are there in order to protect consumers. The current legal regime in Ireland, food law, comes really from the FSAI Act, which was the act setting up the Food Safety Authority of Ireland in 1998. Just as an interesting aside, the Irish Food Safety Authority was the first such food safety agency to be set up in Europe. Whilst there are now food safety agencies in every member state of the European Union, it was actually the Irish Food Safety Authority was the first one to be established in 1998. And in that act, the 1998 Act, a lot of the powers and the responsibilities are contained. Most of you, I'm sure, will be familiar with the General Food Law Regulation, which is a European regulation, which was introduced in 2002. This is what's commonly known as General Food Law. And this is the piece of legislation, this is the law that really sets out the responsibilities and the requirements on food businesses and indeed feed businesses for animal feed. It sets out the rules around traceability and around recall and withdrawal. So it is the basic law that governs the whole of the food sector. In 2005, there was a whole new set of hygiene rules that were introduced, and they consolidated the old rules. So there is a new hygiene package. Of course, I suppose it's not that new anymore, but it has been around now for quite some time. There's also, and it's less relevant perhaps in the context of caterers, but the area of health and nutrition claims. There is legislation around health and nutrition claims, what you are allowed to claim on a food. Are you allowed to say that it improves your health in any way, or in fact make a nutritional claim, so to say that it contains a particular vitamin or mineral. And there is law and rules around what you can say and how you say it. And only authorised health claims, those which have been authorised by the Commission, are permitted to be used on food, and the ones that are authorised went through a very onerous authorisation procedure, and they are available on the internet, and there is a portal which the European Commission portal which lists all of the approved and authorised health claims. It's important to note that regardless of health claims, it is not permissible to make any claim on a food that a food treats, prevents or cures any form of human disease. So you may not make any medicinal claim on your food, but you can make approved and authorised health claims provided that your food contains the specific ingredients. And similarly, there are rules around nutrition claims. The Food Information to Consumers legislation, commonly referred to as FIC, is the legislation which governs exactly that, the information that must be provided to consumers in relation to the food they are buying and consuming. And so that deals with food labels, it deals with information on the internet, on websites, on social media, it deals with any information in relation to a food that is given to a consumer. And there are some very strict rules there in terms of what is required and the way in which that information must be provided. So, for the purpose of today, this is, as you will appreciate, a very large area of law. We could talk about it all day, if not all week. So we're not going to be able to look at all the aspects. So what I'm going to try and do is pull out some of those key messages that relate to the area of allergens and of due diligence, and some of the really fundamental issues that arise in catering establishments. And for that purpose, we're going to look mainly at the area of traceability, hygiene, and allergens themselves. And you find that most of the food safety issues that arise in a food business are related in some way to one of these three headings. So traceability. What is traceability? Traceability is defined in General Food Law Regulation 178 as the ability to trace and follow a food, a feed, food-producing animal, or a substance intended to be or expected to be incorporated into a food or feed through all of the stages of production, processing, and distribution. So that's a very long-winded way of saying traceability means you need to know where your food or ingredient or animal feed has come from and where it has gone to, right through the whole system. And the legal requirement is what we call a one step up, one step down requirement. What that means is that I need to know, if I have purchased an ingredient, I need to know who I have purchased it from, and I then need to also know and be able to tell the authorities who I have purchased it from, what I've done with it, and who I have sold it on to. So it is, I need to be able to go one step back in my process and one step forward. And that applies right across the chain, from primary processing, right through manufacturing, wholesale distribution, retail, so that would also include caterers, so whether it is a shop, whether it is a hospital canteen, a restaurant, an office canteen, a stall selling food, anything like that, you need to be able to say where you've got the food or the ingredient and where it went to, ultimately to the consumer. So the idea behind this is that there is full traceability right across the chain, and this traceability gives visibility to the integrity of the food chain and allows for where there may be incidents of food contamination or where there may be a problem with the food along the way. This system of traceability is supposed to allow you and allow a food business operator and indeed a regulator to pinpoint where that issue arose and to manage any risk associated with that. So it is a legal obligation for all food businesses to be able to trace where their food came from and where it went to. Similarly, it is a legal obligation that every food business operator operating in Ireland and indeed across the EU must have a HACCP system in place. So a HACCP system, food management system in place. And all of you working within the food industry or with the food industry will be very familiar with this. HACCP, Hazard Analysis Critical Control Points. And the purpose of a HACCP system, and you know, HACCP systems can vary. It depends. If you are a large multinational global producer of a particular food, you will have a very detailed, very complex HACCP system that will cover all the production and the intake, goods coming in, goods going out, and the entire system within your facility. If you have a sandwich counter in your local SPAR and you are responsible for that, you will also have a HACCP system, but it will be a much simpler HACCP system. And the whole thing about HACCP and about hygiene and, you know, this obligation is that it is designed that a food business operator, an FBO, looks at what they're doing and identifies where is there a hazard? What am I doing? If I am making ice cream, there is obviously a hazard if that ice cream is not maintained at the correct temperature. So if I have ice cream and I'm not maintaining it at the correct temperature, then that can lead to a hazard. That can allow there to be some issues with the particular product, and you can have some microbiological issues there, and that will become a hazard because it may actually cause illness in your consumers. So the hazard is identified as being the temperature control. You then analyze that and say, okay, if there is a failure in my temperature, would that failure be critical? And if that failure would be critical, then you are obliged to put a control point in place. And so you often see HACCP signs in restaurants or in food preparation areas, say for example by a sink, and that would be one hazard control point, and it would be identified because of course we all know how important it is to wash your hands, and particularly after handling food, raw food and cooked food, how important it is for those working in the food service sector to ensure that there is no cross-contamination. And this is, of course, hugely important when we look at the whole area of allergens and cross-contamination. So in that situation, something as simple as having proper and adequate hand washing facilities and making sure that that is fully incorporated into your HACCP system, and indeed that all your staff are fully trained and made aware of the reason for this HACCP system, that if you are handling food, there is a potential for cross-contamination, and that cross-contamination can cause illness and, on occasion, death amongst consumers. So it is very, very important. And similarly, going back to the traceability point, that is essential in the whole allergy management and allergen management in a particular facility. So knowing what you have bought, the details of every ingredient, where they have come from, and where they are going to. So that whole traceability system, being able to track and trace the allergens that you are using in your business, is essential in a proper allergen management system, as is having a very good HACCP system and making sure that those people who should be trained are properly trained, and the reason for that should also be very much explained to food service operators. So, allergens, and we have already mentioned allergens insofar as in the context of traceability and HACCP, and allergens are really one of the most serious and one of the biggest issues in food and in serving food and selling food to consumers. And in fact, if you look at the Food Safety Authority's website and look at the recent alerts that have been posted on the website, you will see that a huge number of those relate to allergens. So whether the allergen warning on pack has not been correctly given and the allergens have not been properly identified, or whether a product contains an allergen or contains a different allergen to the one that has been included, a lot of those issues end up being cause for product to be withdrawn from sale and a notice on the FSAI's website. And I know that the FSAI and indeed Safe Food and the allergy associations are all very active in communicating these issues in a bid to keep consumers safe. So when we look at allergens, there are really two sets of criteria, or two separate things that we look at. We look at allergens in pre-packaged food. So when you go into a supermarket and you buy something off the shelf that is in a pack where there is a label, that is a pre-packaged food. So whether that is a packet of biscuits, or it is a ham and cheese pizza, or it is a yogurt, they are all pre-packaged food, and they are subject to the Food Information to Consumers legislation and also to allergen labelling. And allergen labelling was first introduced in Europe in 2003. So since 2003, allergens have had to be labelled. But the FIC legislation, which was implemented on the 13th of December 2014, changed the way allergen information needed to be labelled on a pre-pack. So previously, you may recall, if you bought a ready meal or you bought a product which contained one of the 14 allergens, it would have been contained in what we called an allergy box. So you would put in contains eggs, contains milk, contains gluten, and that would be in a particular allergen box separate from the ingredients listing. The Food Information to Consumers legislation of 2014 changed that and said that from now on, the actual allergens themselves need to be highlighted in the ingredients listing. So there is no longer a separate allergen box. There is now a requirement to either bold or to highlight in some way the actual allergen in the list of ingredients on the product. So for pre-packaged food, the allergen needs to be labelled on the ingredient listing, and it needs to be in bold or in some way highlighted so consumers can see it very easily. If you look there, they are the 14 allergens in law, currently in law. They are cereals containing gluten, and some are exempt. For example, wheat-based glucose syrup, milk. Unless some milk derivatives are also exempt, but they are whey, which is used for alcoholic distillates. But actually, in principle, any milk or dairy needs to be labelled and is an allergen. And of course, you have eggs, and then there is fish. But fish gelatin, which is used as a carrier or used for vitamin preparation, is not included. But all of these things are included, and if there is any of these products or derivatives, with some very minor exceptions, they need to be labelled on your label. The 14 allergens are contained, in fact, in Annex 2 of the Food Information Regulation. And they are the allergens which food business operators need to provide information to the consumers. So for anything else, any other information you provide to the consumer is voluntary, but this is mandatory and must be provided on prepackaged food. The other thing is the non-packaged. And non-packaged, there is also a requirement in law that non-packaged food or food packed in front of the consumer must also contain this information. And in Ireland, the implementing legislation in Ireland, implementing the European food information to consumers, specified that in Ireland, in catering establishments and where food is packed in front of the consumer, so that might be if you were ordering a sandwich, or if you were going into a petrol station and you're saying, can I have a sausage roll, or a slice of pizza, or whatever it may be, or a scone, they are put into a bag, packaged in front of you, and they do not carry a label as such. But those products must also declare the allergens, and that information must be given in writing in Ireland. It is not enough. In the UK, they have a different system whereby the consumer must be informed, and they can be informed orally by the food service operator. But in Ireland, it needs to be in writing, and there are different ways that can be done. You can have it in an allergy Bible. You can have it listed on the menu. You can have it on your sandwich board. It can be listed, as you often see, where you have a label or a name coming out of the particular food in a deli counter, for example, and they will list the various different allergens. So that is looking at the allergen labelling. As I say, allergens in Annex 2 of the Food Information and Consumers Regulation, FBOs have got to provide information to the consumer if the food contains any of the following, and they are, as listed in the previous slide, the 14 different allergens, and the actual exemptions are also given there, but there are very few exemptions, and really it is much better to look at this and to take this at face value, and for these allergens to be listed and to be labelled, and for information to be given to the consumer where they are present. So the specific requirements for pre-packed food, so this is back again to the foods that were packaged before they were offered for sale, so food that come with labels on them. The specific requirements for those type of foods is that they must either be fully or partly enclosed by packaging. The contents cannot be altered without opening or changing the packaging, and that they do not include foods packed on sale on the sale premises at the consumer's request or pre-packed for direct sale. So for example, as I said, going in to a deli or into a sandwich shop and ordering a sandwich to be made up for you, so one that is not already in a pre-pack, and there are specific requirements for those. Allergen information must appear directly on the packaging or on a label attached thereto, and that is Article 12 of the regulation, which says that allergen information must appear directly on the packaging or on a label attached thereto. In terms of the non-pre-packed food, and again, this is where we talk about menus and talk about food that is ordered in catering establishments or in canteens, or where you have a buffet, or where you're going into a deli counter. So non-pre-packed foods, the foods that do not come in a ready pack, or that are not packaged in a facility and then sent out and sold on the shelves. So non-pre-packed food include foods offered for sale without pre-packaging, or packed on the sales premises at the consumer's request, or pre-packed for direct sale. So that's the sandwich or the sausage roll, or whatever it may be, that is, or the butchers, or whatever it is, where it's actually packaged and put into a bag and wrapped in front of you. But FBOs, food business operators, must still provide allergy information. However, there is no requirement to do it on the packaging or the label. And this is the thing where I said it needs to be in writing. It does need to be in writing, but it does not need to be actually given on the packaging or the label. You can stick a label on it, but you need to have it in writing, whether that is on your menu or somewhere else on close to the food. If you see there in the UK, as I said, because member states were allowed to adopt national measures about how and where allergen information is displayed to the consumer, the UK, in their food information regulations, said that allergen information can be available by any means they choose, including orally. So in the UK, it is up to the particular food business operator how they actually give this information. They must give it, but it's up to them to give it by any means they choose. If orally, then they must indicate that the allergen details can be obtained by asking a member of staff, and the indication must be given either on a label attached to the food or a notice, menu, ticket or label that is already readily discernible by an intending purchaser at the place they choose the food. So in the UK, it is okay for a member of staff to outline what on the menu or what on the available for sale contains allergens. In France, the situation is like Ireland. The allergen information must be in writing on the food itself or close to it in a way that excludes any uncertainty regarding the food concerned. Whereas in Ireland, all allergen information is to be provided in consumers in writing at the point of presentation, sale or supply. And it is insufficient for staff to orally provide the information. So it is important to remember that distinction. If you are selling food which you are packaging, either you are wrapping on your premises at the instruction or the request of a consumer, or indeed you are running a restaurant or a canteen or a coffee shop or a hotel or any type of food service business, it is not sufficient for the staff to orally provide the information. The information must be in writing. Most restaurants now have allergens listed either on the menu, or they have a separate allergen Bible which is clearly visible to customers. So you would often get a menu, and that will identify which foods contain gluten, which foods contain egg, which foods contain dairy or milk, and you will see, and you'll be all familiar with this, where there may be a guide or a coloured guide on the menu which would call out the various different allergens, or there are numbers and it may contain 1, 5 and 6, and that might relate to sesame seeds, and might relate to some egg, or it might relate to one of the other allergens that need to be listed, maybe perhaps mustard or something like that. So the information has to be provided in writing. Here is an example of the Food Standards Agency in the UK, of their allergy and intolerance sign. And so this is something you may see in the UK or in Northern Ireland in premises. Food allergies and intolerances. Please speak to our staff about the ingredients in your meal when making your order. So that is a signal to consumers in the north of Ireland or in the UK that, you know, if you have a food allergy or if you are intolerant, please ask our staff about the ingredients when you're making your order, and they can give you that information orally. That is not acceptable under the law of Ireland, and in Ireland it needs to be in writing. So We're going to look here at the prohibition, the provision of information, and distance sales. And really in this, in the context of allergens and food, when we say distance sales, we basically mean delivery. And as we all know, there has been a huge increase in the number of food delivery services in Ireland over the last number of years. So whether that is Deliveroo, Just Eat, Uber Eats, or whether it is simply calling up a local takeaway and having food delivered, it is now a very popular way of people consuming food at home. So not necessarily going out to a restaurant, but ordering food either from a restaurant or from a takeaway, and having that food delivered. So we will look at that because there has been a huge increase in that, and it is an area that is particularly sensitive around allergens and particularly open to problems when it comes to allergens. But first of all, looking at the prohibition, there is a prohibition in respect of the presentation, sale and supply, and this is the actual provision in the SI, which is the Irish Implementing Legislation 489 of 2014, which implements the allergen rules in Ireland. And that says at section 4, a food business operator shall not present or make food available for sale or supply, or sell or supply food, unless written particulars of any allergen in the food are indicated at the point of presentation, B, the point of sale, or the point of supply. So again, it needs to be in writing. The manner in which the information is to be provided in Ireland: the FBO must provide written particulars. It must be before the sale or supply. So the consumer must know before they actually buy the food what the allergens are in it. The information may be given in English or in Irish and English. It must be conspicuous and easily visible. It must be legible, and it must avoid consumer confusion. Distance sales, so looking at the delivery business, food delivery business and distance sales of food. The rules and the law require that in this instance, the allergen information must be available to the consumer before purchase. So when they are looking at whether it is on the website or whether it is looking at a takeaway menu that may have come in through their letterbox, the information must be there before they purchase the allergen information. And it must also be available at delivery, and it must be in writing at least at one stage. So either it is on the menu when they are ordering the food and it is in writing, or it is in writing on the receipt at the time that the food, or perhaps written on the takeaway carton at the time that they receive the food. So the information must be given both before purchase and at delivery, but it needs to be in writing at least at one stage. So for example, it could be a situation whereby the information before purchase, the information is given to the consumer over the phone, for example, in terms of the allergies, but that information must also be given at the time the food is delivered, and at that point it must be given in writing if it hasn't been given in writing previously. Turning to other general principles for the mandatory particulars, or in English, the do's and don'ts. It is important that allergen information is available, is easily accessible, is marked in a conspicuous place so as to be easily visible, is clearly legible, is indelible, so you can't rub it out, or it can't get, and again, if we're talking about food delivery services, there's no point in writing it in ink that if your Deliveroo guy is on his bicycle and it's raining, that suddenly it's gone and the information is no longer there. So it must be indelible, and it must be in a language easily understood by the consumers. And again, that's an important thing for food service operators to remember, that you may have a shorthand in the kitchen or there may be something that is understood within your business, but that may not be easily understood by consumers. And so it is important that that information, and whether this is in a restaurant, as I say, in a deli, in a hospital, in a canteen, any food service provider, needs to be in a language that is easily understood by consumers. And this particular issue has come up in a number of cases, for example, where you might be talking about some form of perhaps Indian food or Chinese food or Korean food, and so where the chefs and the food preparation people and food service people may in fact speak a separate language and a different language, a language that is not necessarily understood by the consumer. It's not enough for the allergens to be labelled in that language. It needs, of course, to be labelled in a language understood by consumers. The other thing is that one should be very careful to make sure that allergen information is not hidden, that it's not obscured, or that it's not detracted from or interrupted by any other written or pictorial matter or any other intervening material. So, for example, there's no point in saying, well, we had the allergen information on our takeaway menu if, in fact, you had a big 10% off or get a free Coke label or sticker posted over it. That would not be good enough, and that would not be compliant with the law. So you need to make sure, and you need to really pay attention to the fact that if you're going to the trouble of fully complying with the law and having all of the allergen information there, you want to make sure that those that are affected by this actually have access to that information. So it should not be hidden, obscured, or detracted from in any way. Of course, the law always has exemptions, and there are exemptions, although when it comes to allergens, there are very few exemptions. Food from automatic vending machines is not covered by the legislation. I'm not entirely sure why that is, and it doesn't seem to make sense, but it is the case. Food from automatic vending machines falls under one of the exemptions. And also, and this one makes more sense, when the allergen is in the name of the food. So obviously, if you're buying a pint of milk, you don't have to label on the ingredients listing milk being an allergen, because obviously, it is milk, and if one is lactose intolerant or allergic to milk, then they wouldn't be buying a pint of milk. Similarly, if you're buying eggs, for example, or if you're going and you're buying mussels, all of these things, peanuts, if peanuts are in the name of the food, then you do not need to give additional labeling information. So they are two exemptions. As I say, the first one, I'm not entirely sure that makes sense, again, because we're seeing an increase in food being sold from automatic vending machines. But certainly it makes sense that where the allergen is in the name of the food, there isn't an additional requirement to label that. So let's look at the due diligence defence. This is something that we were keen to look at in this webinar because it is very onerous and it is a huge responsibility on caterers and food business operators to comply with the law and to make sure that all of the food that they sell and offer for sale is fully compliant, and particularly in the area of allergens, where there can be issues, where things can go wrong, where there can be cross-contamination, and where, even with the best will in the world, there can be issues. So the law does provide for a defence, and that is called the due diligence defence. In Ireland, it is a rather new defence, but it has been established in the UK for quite some considerable time, and we will look at that. We're also going to look at just some case studies just to identify when allergen labelling goes wrong and what can happen, and then maybe look at some preventative measures. So what can you do to make sure that you do not, and your business does not fall foul of some of these problems, and that you avoid the getting into difficulty, or indeed your consumers getting into difficulty because of a bad or ineffective allergen management scheme. So Due diligence in Ireland is governed and was actually introduced into the law of Ireland on foot of Section 5.3 of the statutory instrument which implemented the General Food Law Regulation. So that was SI 747, easy to remember, 747 of 2007. And Section 5.3 of that actually introduces this defence of due diligence. And it states that it is a defence for a person charged with the offence to prove both of the following. The commission of the offence was due to a mistake or the reliance on information supplied to him or her, or the act or default of another person, an accident, or some other cause beyond his or her control. And they must also show that he or she exercised due diligence and took all reasonable precautions to avoid the commission of the offence. When we talk about the offence in this instance, we are talking in this context about incorrectly or either not labelling an allergen or incorrectly labelling an allergen. So if you were being prosecuted by a local authority for incorrectly labelling allergens or for not labelling allergens, it would be potentially a defence for you to say that you committed this offence, but it was due to a mistake or the reliance on information supplied by another person or an accident or something else beyond your control, and also that you exercised due diligence and you took all reasonable precautions to avoid this happening. In Ireland, as I said, this is a very new defence, and again, I say very new, I suppose it was introduced in 2007, but in legal terms, that is still a very new defence, and we do not have a significant body of practice where this has been used. However, in the UK, it has been used and has been a statutory defence in their Food Safety Act for many, many years. And so here, when we look at this defence of due diligence, we have to look at it and assume that it will likely to be based on UK practice and procedure. And so that really is the best guide that we have. How does it operate in the UK, and what has been the practice and procedure there, because it is likely that Irish courts and a judge would look towards the UK because they have developed this particular defence in a much broader way than we have. And so if it is to be based on the UK practice and procedure, we will see that traceability, internal auditing, external auditing and supplier checks will be very important. So mounting a successful due diligence defence based on UK precedent, it's important to remember the burden of proof lies on the defendant, so on the balance of probability. So the defendant, where a prosecution would be taken in this instance where there was an allergen was not labelled, the food service operator would effectively be the defendant, and the burden of proof lies on the defendant, the person who is accused of committing the offence, and it is based on the balance of probability. There is a positive duty to act to avoid committing an offence. So the duty is to be a positive act. You need to do something to make sure that you have avoided committing an offence, and that will be back to having an adequate traceability system, having a properly working and operating and monitored HACCP system, and being able to show that an effective system was in place to prevent the breach of allergen laws, and that was being properly implemented. You know, it's not enough to say, oh yes, well I paid a consultant to come in and they did a fabulous HACCP system for me, and I have all of the books and I have all of the signs and everything else, if it is not actually being implemented. So it is essential that the actual system that you have within your business is properly implemented and is properly updated, and that records are updated, and indeed that staff are regularly trained and informed about it. And it is if you are looking to use and employ a due diligence defence, then you really need to make sure that you can show that you have an effective system and that you have implemented it and that you have trained people on that implementation on a regular basis. The defence will be stronger and therefore more likely to succeed if there is written evidence that the necessary systems, tests and inspections were put in place and carried out regularly. So therefore, if you can show that you have a record, for example, of bringing in your ingredients, if you have recorded all of the ingredients that come in and you have all of your traceability systems and all of this is in written evidence, that you have the results of tests that were carried out or indeed inspections that you carried out on a supplier or on a supplier, on whoever is supplying you with the particular ingredient. If you show, well, I did an audit of that facility 6 months ago or 3 months ago or 3 weeks ago, and here are the details. And I checked in this facility, do they have an allergen management system? Is there, are there controls on cross-contamination? And indeed in your own facility, do you have cross-contamination controls, and are they actually evidenced in writing? Where there is written evidence and proof, then that makes the defence of due diligence a much stronger defence. Also important to look at the extent and level of checks carried out, and that depends, of course, on the company's size and resources. As I said earlier, if you are a small food business operator and it is for example, a convenience store with a deli counter that is a small size and there may be one person working in it or two people working in it, the level of checks carried out and the extent of those checks are not the same as if you have a very significant food business or food preparation. If you are, for example, a hotel and you are catering for weddings and for events and you are, producing a huge amount of food on a regular basis for your guests and for diners in your hotel, then you would be expected to have a much more sophisticated system of checks, and they would be expected to have been carried out on a regular basis. And so each case is judged on its own merits. What are the resources and what is the company's size? So just a reminder, you can claim and you can look to a due diligence defence in a situation where you are being prosecuted by a local authority, so prosecuted, for example, by an EHO, by the HSE or by the Food Safety Authority itself or any of its official agents. You can launch a due diligence defence on the basis that a mistake was made. And so mistakes are made and mistakes can be made. So a mistake was made, or the reliance on information supplied to you. So if you say, well, I was told by my supplier that there were no peanuts in this particular ingredient, and I have that in writing, and I have audited that supplier, you are then demonstrating that you have taken reasonable precautions and exercised due diligence to avoid commission of the offence. So if you say, I went out, I visited this place, I asked them, I specified I needed no peanuts in whatever it may be, and if you can show that, and simply as a mistake or relying on information that was supplied to you, the offence was committed, then you can use and you can try and rely on the due diligence defence. Or of course, if you say, well, look, the act it was not my fault, it was somebody else. I wasn't responsible for preparing the sandwich or for making the curry or for whatever it may be. Or an accident, if, for example, something leaked or there was an accident in the kitchen or an accident happened and some other cause outside of your control. So you need to show that, but you also need to show, so you could say it was a mistake or you relied on something else or it was default of somebody else. But you also have to show that you have a proper system and that you have taken all reasonable precautions to ensure that the offence was not committed. And in doing those things, you are putting yourself in the best possible position in a situation where an accident or a mistake may happen. And that really is the essence of the due diligence defence. And just, to look at a couple of examples of where things did not work out, and where some unfortunate people lost their lives as a result of allergens and the allergen laws not being adhered to. You look here in November under the Just Eat. In November 2018, which is not that long ago, only a couple of months ago, a takeaway owner and a worker were jailed for manslaughter of a teenager who died after eating a takeaway that was ordered via the Just Eat app. The friend was doing the order, and she specified prawns and nuts in the notes section of the app, but the request was ignored. One of the dishes delivered contained unlabeled peanut protein. The girl was allergic to that, and as a result, the girl died. And when you looked at the online menu, it simply said on the online menu, think allergy and please ask any member of staff. The subsequent police investigation found that there was no allergen management procedures at all, and as a result, this girl lost her life. And so the takeaway owner and the worker were jailed for manslaughter. In the case of Pret, on the right of the slide, in July 2016, this is the 15-year-old girl, Natasha, who died after eating a Pret baguette which contained sesame seeds to which she was allergic. The allergen was not labelled on the baguette packaging, and this would have been a pre-packed product which was in I suppose a Pret store, so it wasn't labelled on the packaging, as Pret had chosen to use an oral warning system, as they can do in the UK, whereby signs throughout the store advise customers to ask staff about potential allergens. Pret reacted in October 2018 when the coroner's report or the coroner's inquest was on by promising to label all ingredients and allergens on its products after the coroner found that Pret's labelling was inadequate in September 2018. So this was an example of Pret opting for this UK provision to orally provide the information through its staff. If you see here on the food delivery apps, who has responsibility, and you look at, when you look at the small print, you see that Just Eat, that there are disclaimers saying that when a restaurant signs up to them, they have to have up-to-date menu information, which is on the website. So they're very much pushing back the responsibility onto the restaurants, and they say if you have a concern about food allergies, intolerances or other dietary preferences, you should always contact the restaurant directly before placing your order. Please do not use the leave a note for the restaurant box for your food allergies or intolerances. Please contact the restaurant directly. And that, if you remember from the previous slide, was what the friend had done. So Just Eat has now updated its disclaimer to say that's not good enough. You need to contact the restaurant directly if you have a food allergy. And it also then goes on to say that the legal contract for the supply and purchase of products is between you and the restaurant. So they are saying that they are not responsible, and it is very much down to the restaurant. Deliveroo, they similarly say that the partner restaurants may use nuts in the preparation of certain meals. Please call the restaurant prior to ordering if you have an allergy, because Deliveroo cannot guarantee that any of the meals sold by our partner restaurants are free of allergens. So they are very much putting the responsibility back onto the restaurant and the food business owner. So that is important, that you do not, if you use these services either as a consumer or indeed as a food business to distribute your products, you are still ultimately responsible. So it is important to make sure that you pay attention to that. Then we saw in May 2016 an Indian restaurant owner in the UK was also jailed. He was jailed for 6 years when a consumer, Paul Wilson, and he died after Mohammed Zaman, who was the name of the restaurant owner, swapped almond powder for a cheaper powder containing peanuts. And the judge said that the restaurant and the owner displayed a cavalier attitude to safety and put profit before safety. And this guy, who was the restaurant owner, was jailed for 6 years. So there are very serious consequences to not getting your allergens correct and to making errors, or indeed to putting profit before safety. So it is something that every food business operator should be fully aware of. There are, of course, other issues around free from foods and multi-packs. So free from claims on labels, whether it's free from milk or peanut free, these should always be based on specific and rigorous controls. The final product should be completely free of the allergen. If you are saying it is free from, then it must be completely free of the allergen. You must have checked for cross-contamination. So is there any way that this product could have been contaminated? And this goes to the overall safety statement, since it acts as a guarantee. If it was labelled with the claim lactose free, but it contains lactose, this will impact on the safety statement. There is an exception for gluten-free labelled products, and that exception in law says that gluten-free products can contain a maximum of 20 mg per kg of gluten. So there is a small exemption, but really one should not rely on that and should simply make sure and cross-check that the final food is free of the allergen. When products are sold in multi-packs, the allergens must be displayed on the outer packaging. It's not enough to have them on the inner packaging of a multi-pack, because of course then the consumer does not have the information prior to purchase. So what can you do? How can you protect yourself so that you never get into a situation of either having to use a due diligence defence or indeed defend the position that you find yourself in? And how can you also make sure that you properly and adequately serve your customers and give them the information that they require, particularly those who do suffer from very serious food allergies? Some of the measures that can be taken by a food business operator we have already discussed. They relate to traceability, having a proper and really robust traceability system, making sure that you conduct regular internal audits. So, as I say, that's back to the, oh, well, we have a HACCP system and it's great. Yes, but when was the last time you actually tested it or made sure that it was being enforced and properly adhered to? So, internal audits of your own systems. And of course, external auditing. And you are only as good as your supplier. So who is supplying you? Do you have confidence in your supplier? Do you trust them? Are they giving you the correct information? Do they have the right systems in place and the right controls in place? You really only get that by actually conducting external audits, by going in unannounced or whatever else it may be and saying, I want to have a look here. I'm sourcing product from you, so I want to have a look and see what you're doing. Also supplier checks, and that's a similar thing to the external auditing, really checking out your suppliers. It may not always be possible to do an external audit, but who are you buying from? Do they have a good reputation? Are they established in the market? What kind of a supplier are they? So checking up on them, making sure that you are confident that you can trust your supplier and that they are doing things the way they should do them and giving you the information you require. I've mentioned it a number of times during this webinar. Staff training is essential, and particularly in the food service business where there is and can be quite high staff turnover. There's no point in having a training day once every 6 months if in fact your staff typically only stay with you for 6 weeks or for 8 weeks or on a seasonal basis. So staff training, it should be essential. Every new member of staff should be trained from a food safety perspective, and they really must understand. You need to explain to them why it is so important to wash hands, to clean up, not to cross-contaminate, to separate raw and cooked, all of those things which are covered by your HACCP system. It's important that they understand why you do this. It's also important that when you look at allergens and food allergies, that those working with you and for you, that they understand the implications. It's not simply, and I'm sure, those of you who run restaurants and work in the food service sector, you're well used to fussy customers and people who want this, that and the other, and looking for no gluten, or they don't want bread, or they don't want to consume something or other. And that may be simply because they're intolerant, or they're on a diet, or they're just a fussy eater. But that is a very different scenario to somebody who is suffering from a food allergy. And I know this myself because my sister is in fact a celiac, and I'm more vigilant than she is. If we go out for dinner, I'm constantly saying no. But she's a celiac. She's not just fussy. She's not intolerant. She is a celiac, and you're going to ruin our night if you give her anything with gluten in it, because she gets very seriously sick. So I think it's important in the staff training that people understand the consequences and understand why these systems are in place. And also, as I mentioned earlier, recording and, where appropriate, acting on consumer complaints. So, where a consumer complains, where there isn't information, or where, for example, like my sister, where they have consumed something and have been sick, it's important to record that, and then to also follow up and take action. So perhaps in a situation like that, where somebody says, I'm celiac, I need to make sure I don't have any gluten, and for some reason they consume gluten, and they call the restaurant the next day or that evening or whatever it is to say, look, I was in your restaurant, I ordered such and such, but I have been terribly sick since then. It's important to record that, to take a note of that, and also perhaps to go and talk to the chef or talk to whoever is preparing the food, and to see, where might this contamination have happened? Is there an error on the menu? Was something used that shouldn't have been used? Was there a mistake? What happened? It's important to do that. And again, all of that and those records show an enforcement officer, when they come in, if there is either a complaint, if you have had an issue around an allergen, if you can show, look, we have a system, we take account, we record it, we record consumer complaints, and we follow up on them, and we always do that. Then you are showing that you have a proper system in place and an effective system, and that you really do take food safety and allergen safety very seriously. And that will assist you in terms of establishing due diligence and being able to show that you are a responsible food business operator who adheres to the law. Allergen information, as we said, it must be in writing and clearly available to consumers. And so that is a preventative measure. If you say, listen, it was there, it's on the menu, it's in writing, it's clearly available, we give it to all of our consumers, that again adds weight to the fact that what more could you do? There's only so far you can go. But if you can point that out and say this information was available to that consumer, if she insisted on ordering something that contained, or he insisted on ordering something that contained an allergen, the information was there and they didn't read the menu properly, but we gave them all the information. So it's that type of thing. They are the things that will help you not have a situation with allergens. And if you do have a situation, will hopefully help you explain it and prove that you did everything in your power to avoid committing the offence. So I mentioned enforcement, and I think it's important to look at enforcement and to see where we are going in enforcement. If you look at enforcement under the Official Controls Regulation, there are very wide enforcement powers, and they allow seizure of food, removal, detain, destroy any food or relevant thing. There is also a compliance notice where an authorised officer can order recall or withdrawal or prohibit the sale of food. And also where they can say, look, you need to correct this, the hygiene is not correct, the washing facilities are not correct, whatever it may be, and failure to do that can be an offence. The official control officers have the power to issue improvement notices, improvement orders, closure orders or prohibition orders. All of these things can be done and are done. They can also prosecute you. And indeed, if any of these enforcement action is taken against a food business operator, it will be named and shamed on the Food Safety Authority website, and you will often see every month the notices in terms of the closure orders, prohibition orders, improvement orders. They are all published and there for all the public to see. So there are wide enforcement powers. For offences under the SI, under the Irish legislation, it's an offence to obstruct or interfere with an authorised officer, failing to give or giving the incorrect name or address, failing to comply with a request or a notice, giving false or misleading information, altering or forging documents or records, having a forged or altered document, or tampering or interfering with any food or sample. All of these are offences. So, do not fall foul of this. Do not think, oh my goodness, I don't have the relevant traceability information. I'm just going to write it, or I'm going to forge it, or I'm going to alter it. They are all offences and you could be prosecuted. And it's important to remember, food law prosecutions, breaches of food law are criminal breaches. They are criminal offences and they are treated as such by the courts. So it is important to make sure that you do not commit an offence under food law in this country. And what happens to you if you do? Well, there is liability and there are potentially criminal penalties. Liability in a legal sense, there can be civil liability, criminal liability, or personal liability. Civil liability is where you are negligent and where you're sued by somebody who comes into your restaurant, and they can sue you if they fall over, if they slipped and fell. They can sue you if the floor is greasy and you have a supermarket or something like that. So that is where there has been negligence and somebody has suffered injury or damage, and they will sue you generally for damages, so for money. Criminal liability is, however, as I was just saying, it is a criminal prosecution, and food law, a breach of food law, is a criminal offence. The same way as a driving offence, driving under the influence, parking, any of those, driving offences are criminal offences, as are breaches of food law. And of course, we have personal liability, and personal liability is where it is actually down to the person themselves, and not the entity or not the business or not the company, but the person themselves is personally liable. That, of course, is a scenario if you were held to be personally liable and a court awarded substantial damages to somebody. It could be your home that could be affected. It could be your own personal property that could be affected there. And so it's important for people to realise that the law provides for personal liability. When we talk about criminal penalties under the Food Safety Authority of Ireland Act, there is conviction on indictment, that's in front of a jury, of €130,000 and or 12 months imprisonment, or summary conviction for a less serious offence. There can be a fine of up to 1,900 and or 3 months imprisonment. It is often said to me, I often have clients who say, oh, well, I work for such and such a company and they're my employer, and sure, it'll be them if there's an offence, they'll be prosecuted. But as I said, there is also personal liability, and the law provides for imprisonment. You cannot put a company in prison, you can only put a person in prison. So that is something very important, and as I've shown in some of the previous case studies, it is not unheard of for people to be sent to prison for breaches of food law. General food law regulation, the overarching food law regulation, says that a person who is guilty of an offence under the regulations is liable to a fine not exceeding 5,000 or imprisonment, or on indictment to a fine not exceeding 500,000 or imprisonment, or for a term not exceeding 3 years. So they're fairly serious implications if you are found to be liable of committing an offence and convicted. Personal liability, here's a situation where directors' liabilities, a case in Ballybay in County Cavan where a company was fined 14,000 plus costs, but more importantly, 2 directors were sentenced to 4 months in prison, and it wasn't suspended. So they went to court that day, they were found guilty, and they were sentenced to 4 months imprisonment, and they were taken away in handcuffs. Now, The judge said that during sentencing that they were very serious offences and that the offences showed a high degree of recklessness and irresponsibility towards public health. In this case, the case was appealed by the two defendants and the appeal was upheld and they were released from prison. But the reality is it is not unheard of, and particularly where public health has not been taken seriously and the law has been breached, there can be very serious consequences. Food shall not be placed on the market if it is unsafe, and food shall be deemed unsafe if it is considered to be injurious to health or unfit for human consumption. This is important also in the area of allergens, because if you are putting a food on the market that is not properly labelled, then it could be injurious to the health of somebody who has an allergy, or it is also in fact unfit for human consumption. If I'm a celiac and you're supplying me with some food that contains gluten and it isn't properly labelled, then it is unsafe under Article 14 of the General Food Law Regulation, and there is a whole series of things that flow from that. Unsafe food, in summary, can have an adverse health effect or can be unacceptable due to contamination, spoilage or taint. Placing on the market is something that we often come across, and again, it has a much broader legal definition than what people often think. Placing on the market means the holding of food or feed for the purposes of sale to any other form of transfer, whether free of charge or not, and the sale, distribution and other forms of transfer themselves. So even if you are not selling a food, if you are actually going to be giving it away free, you still have obligations and that food still has been placed on the market. So you may simply be trying something out, it might just be sampling, it might be market research, but that is still placing it on the market, and in that situation you still are obliged to comply in full with the rules, and in particular with the rules around allergies. So how can you stay in business and out of jail, which I presume everybody would prefer to do? You need to be aware of liability. There are very serious consequences for not complying with the law, and there can be very serious personal costs, not just monetary, of not complying with the law. Of course, if you are one of those companies that are up in headlines, if you are Pret or you are Just Eat or you are that Indian takeaway and you are up in lights and in the headlines and in the news and on social media because of a breach of food law, and particularly because of an allergen issue, you can assume that you will lose customers, that you will lose your reputation. There are also very specific costs around scientific evaluation. Actually, the cost of getting testing done, if you're in a situation where you're being prosecuted, there are very serious costs towards that defence. There are PR costs and adverse publicity, as I say, tying into loss of customers. And you also face potential closure and legal action. So really, the consequences of not complying can be very high. And I think the message has to be that the cost of compliance is much, much lower than the cost of non-compliance. So whatever it may cost you in terms of time and investment and resources and training, you should do that and make sure you have done that in a way which means that you are staying in business and you don't find yourself on the wrong side of the law and facing some of these very serious consequences. So on that note, I'm going to wrap up. I have gone over the allotted time, I think, but I think it's important that we do that and that we look at all of these issues. And I am, of course, happy to take any questions and to answer any of your questions that you may have as a result of this webinar. Thank you for joining us today, and back to Tracy.